Welcome, everyone, to this House Caucus of the Whole on February 10th, 2023. Our topic today is the House Discrimination Prevention Training that is required by House Rule 90. The House Discrimination Panel and our staff will be walking us through the discrimination prevention policy. I'm going to now turn it over to Representative Garofano, who is going to introduce the panel and who will be getting us started. Representative Garofano.
Thank you. Good morning. Thank you for sticking it out with us. In the next 45 minutes, we are going to go through our House Discrimination Prevention Policy and rules. And I will be introducing our panel members. We'll be going over the goals of the training. We'll let you know who is covered by the House policy and what is prohibited, go over some definitions, examples of discrimination, and give you a summary of panel procedures and the role of legislative staff, supervisors, and Legislative Office of Human Services. And we'll also share at the end some other additional resources with you. So as Representative Long mentioned, pursuant to House Rule 90A, the Rules Committee appoints 5 panel members at the beginning of each biennium. Your panel members are all standing here. Representative Payala is the chair of our panel, Representative Small, Representative Matos, Representative Burrows, and myself, Representative Garofano. We're also assisted and supported by Legislative Counsel Damian Reynolds. The goals of the training are to understand discriminatory conduct. We hope to educate you regarding your options. Thank you. We're going to tag team here. So we hope that by the end of this training, you will understand discriminatory conduct, and we hope that you will be educated regarding your options if you've been discriminated against. We hope to empower you to make informed decisions regarding whether and how to seek a resolution if you've been discriminated against or if you have witnessed discrimination. And ultimately, we hope to foster a positive culture in our workplace in this building. So who is covered by this policy? This policy covers all House members, all General Assembly staff working in the House. It protects legislators, staff, legislative pages and interns, members of the public, including lobbyists, advocates, and members of the press. So basically, folks that are working in this building. What is prohibited? The policy prohibits discrimination and retaliation for reporting discrimination or cooperating with an investigation of discrimination. So to give you the definition of discrimination, discrimination is the unfair or unequal treatment of a person based on a protected characteristic and workplace harassment based on a protected characteristic. It includes conduct that limits, segregates, or classifies a person based on a protected characteristic in a manner that would deprive or tend to deprive the person of opportunities related to the person's work in the State House, or it would otherwise adversely affect a person's status in relation to that person's work in this building. What are protected characteristics? Protected characteristics are a person's race, gender identity, color, ancestry, religion, place of birth, national origin, age, sex, crime victim status, sexual orientation, and physical or mental condition. Workplace harassment is a form of discrimination. It means unwelcome conduct related to or directed toward a person on the basis of a protected characteristic, which includes conduct that is personally offensive, fails to respect the rights of others, lowers morale, interferes with work, or violates a person's sense of well-being. It can be verbal, physical, auditory, visual, or any of the combination of those. Workplace harassment, it does not need to be severe or pervasive to violate our policy, and it does not include petty slights, minor annoyances, or disappointments that a person may encounter during the person's time in the State House. Some examples of workplace harassment include unwanted or offensive jokes, slurs, epithets, or name calling, mimicking or limiting the characteristics of a person, hazing, physical assaults or threats, intimidation, ridicule or mockery, and insulting or putting down a person. Offensive objects or pictures are examples of workplace harassment. Retaliation of any kind for having filed or supported a complaint of discrimination. This means ostracizing a person, pressuring the person to drop or not support the complaint, or adversely altering that person's duties or work environment. Derogatory or provocative remarks are included in examples of workplace harassment, interference with a person's work, and off-duty conduct that falls within any of these examples and affects the legislative work environment. That means, I want to emphasize that means that it does not need to happen in this building. If it alters the person's work environment, then it is considered a workplace harassment. Basically, we want you to know that we all have the right to a safe and professional work environment free from discrimination. If you are discriminated against, no matter what your position is or the position of the person that's discriminating against you, you have the right to tell person to stop. I am now going to turn it over to Damien, Mr. Leonard, to continue to go over some of the options of what folks have if they experience harassment or witness discrimination, and go through some of our policy and procedures.
Thank you. Before I move on, I think this is a good time to stop to see if there are any questions about what constitutes discrimination. Does anyone have a question about the slides you've just seen? Yes.
Crime victim status was new to me, and I'm just curious if you can talk about that part.
Sure. So Vermont law and our policy protects an individual from discrimination because they've been a victim of a crime. So this could be any sort of harassing behavior or ostracizing a person because they've come forward and reported a crime in their community, particularly if it's a controversial issue, or victimizing the person further because they've reported a crime or been a victim of a crime. So does that answer your question?
It does. I was curious. It sounds like it does not include somebody who has a criminal record.
It does not include someone who has a criminal record.
Thanks.
Are there other questions? Okay. Seeing none. So I'm going to talk to you about what your options are if you've experienced discrimination or if you've witnessed discrimination. So first, if you've believed that you've been discriminated against by another representative in this chamber or a legislative staff person, or if you believe that you've witnessed it, you can do any one of the following things. You can speak with the individual who engaged in the discriminatory behavior. Some of you might be comfortable doing this, some of you might not. You are not required to do this. That's very important, but you are allowed to identify objectionable behavior and ask people to stop. And you should feel empowered to do so if you're comfortable doing that. You can also speak with a member of leadership or a supervisor. This includes your committee chair, the speaker, the leader of your caucus. You can speak with any legislative supervisor about the behavior. and you can ask those people for help. Supervisors and leaders do have a legal obligation to ensure that this is a safe working environment for everyone, so you should feel empowered to speak to them. You can also speak with the Legislative Office of Human Resources. Arlene Donovan and Eliza Giroux are two human resources employees here. They are wonderful resources. They can help you figure out your options. They also have an obligation to ensure that this is a safe working environment for everyone, and they can help you decide how to proceed. And then finally, you can speak with any member of the House Discrimination Prevention Panel who you've just been introduced to. And again, they also have an obligation to ensure that this is a safe working environment for everyone. They can talk to you about your options. They can help you through the panel's both informal and formal processes and explain to you what your options are and how those options and processes look. Because depending on what you may have experienced, if you experience discrimination, the appropriate way to move forward or the way that's comfortable for you may be different. And then finally, you do have the option to go outside this building. You can contact the Federal Equal Employment Opportunity Commission, otherwise known as the EEOC, the Attorney General's Office, Civil Rights Unit, the Human Rights Commission, or a private attorney. Your rights with those organizations are going to depend on whether you're protected by an employment law or a public accommodations law, which could include the Vermont Public Accommodations Act, the Americans with Disabilities Act, or another federal law similar to that that prohibits discrimination on the basis of a protected class. I should also mention you always have the option to speak to one of your attorneys and legislative counsel. My door is always open if you have questions or concerns, and I'm happy to discuss options with you and help you understand whether the behavior that you may have experienced or witnessed violates the policy and what your options might be. It's important to note that leadership, supervisors, the panel, and the Legislative Office of Human Resources, all, because of their legal obligation to ensure that this is a safe working environment, they may be required to take immediate and appropriate action to prevent further violations of the policy, regardless of what the victim's wishes are or the alleged victim's wishes are. This is important because if the behavior is behavior that could repeat, they have an obligation to ensure that your colleagues or the other staff are also safe. So that action can be anything from planning for the individual's safety to having an informal discussion with the individual who allegedly engaged in the discriminatory behavior, working with a supervisor, working with leadership. It's going to vary depending on the situation, but they do have an obligation to ensure that everyone is safe. So, and I've listed the possible actions there. I just went over them. There we go. So this brings us to the panel. When you come to the panel, after the basic informational process, you really have two options available to you. The first is the informal process, and the second is the formal process. And there's really important differences between those two that you should be aware of. And don't worry, if you forget what I'm telling you in the next 2 minutes, the panel members or myself or Arlene Donovan or Eliza Giroux from the Office of Human Resources are available as resources to remind you and talk you through this again if you have questions. So I'll start with the informal process. So this begins when a person who believes they experienced or witnessed discrimination, or a supervisor or member of leadership who becomes aware of behavior that they're concerned might be discrimination, comes to the panel. Starts by contacting the panel member. The panel members will discuss the issue that's been brought to their attention with legislative counsel, Office of Human Resources, or if appropriate with outside counsel, if, for example, legislative counsel has a conflict in the issue and can't be involved. And then they'll also discuss with you your options for proceeding. At that point, they'll walk you through what the procedures look like and talk to you about whether the informal process might be appropriate or the formal process might be appropriate. The informal process doesn't include any findings about whether discrimination actually occurred. It is designed to be a process that promotes healing and sort of repairing the relationship between the parties, and ideally resulting in an apology for offensive behavior and a change in behavior going forward. It is not meant to be an adjudicatory process. The goal is to ensure that the behavior stops and that the parties can continue working together productively. It is confidential, with the only exception being that panel members and panel staff will be discussing the issue among themselves. The formal process is different. It starts with a written complaint from the individual who believes they experienced harassment. It follows with an opportunity for the individual who's alleged to have engaged in the discriminatory behavior to respond to that complaint and make a case as to why they believe they didn't, if they're asserting that. If the complaint states a claim that would be a violation of the policy, so in other words, if it describes events that would be discrimination under the policy, if everything is, if the complaint is completely accurate and true, then it moves to a formal investigation, at which point outside counsel is brought in to do an investigation. They'll conduct interviews with witnesses and the parties. They'll draft a formal report for the panel. And at that point, the panel is going to decide what the next step is. That could include a finding that discrimination didn't occur, issuing a reprimand, bringing the parties together for a mutually agreed resolution of the issue, or scheduling a formal hearing with the parties. And it's a closed formal hearing. It's not open to the public. And it's run in a quasi-judicial manner, meaning the parties can have either someone there to support them through the hearing or bring in private counsel that they hire. The cases are made, witnesses can be called, and the panel will eventually make findings on the evidence before them as to whether discrimination occurred. Again, these processes are entirely confidential, except to the extent that the panel and staff, and if you go through a formal investigation, witnesses may be involved in it. But the panel and its staff are required to keep it confidential. Sorry about that. So that brings us to, in the event that we get to a formal hearing that results in a formal finding that discrimination occurred, what's the potential outcome? So the panel can recommend counseling or training. They can recommend to the speaker's office that an individual be removed from a committee or removed from a leadership post. They can also bring a resolution to the entire House recommending censure or ultimately expulsion of a member. Obviously, these are in rising level of significance and severity. For legislative staff, again, the panel can recommend counseling or training, reprimand, loss of pay or vacation days, demotion, or termination. So again, in ascending order of severity. The panel is required to act as soon as reasonably possible. That statement is deliberately open-ended because the ability to act quickly depends on the time of year. When we're here in person in the building, it's much easier for a panel to get together and meet very quickly. In the off session, it sometimes takes longer for the panel to meet. often at those times, the issue is less pressing too, because there's not a danger of it repeating or continuing in the coming days. As I mentioned before, the panel staff, and any person the panel contracts with, such as outside counsel, are required to keep all related information confidential, except to the extent that they're permitted to talk to each other or to a witness under the policy. Panel records are not subject to the Public Records Act. So if you bring a complaint to the panel or you give a statement to the panel, you don't have to worry about that record eventually becoming public. Everything is kept confidential. And then the panel chair or the speaker will only issue a public statement if the corrective action is publicly noticeable. This would include removal from a leadership position, censure, expulsion, or for staff, demotion or termination. So I want to emphasize again that in addition to your panel and the members of leadership in the House, staff supervisors, and the Office of Legislative Human Resources are a resource both for members and for staff. Legislative employees are encouraged to speak with their supervisors or human resources if they feel like they've experienced or witnessed discrimination. And I would encourage you to speak with leadership or staff if you've either witnessed or experienced it. And finally, as I mentioned before, supervisors, the Office of Legislative Human Resources, and your leadership are all legally obligated to make sure that the behavior stops and that it's a safe environment for everyone. If you want to find a copy of the policy after today's training, it's available on the Discrimination Prevention Panel's website. And it's kept up there year-round. You can download it. Each time it's updated, we update the policy on the website. As I mentioned before, you can also make complaints to outside groups, including a court through a private attorney, the Equal Employment Opportunity Commission, the Human Rights Commission, and the Attorney General. And all of those their contact information is available here as well as in the policy. So if you have questions about who to contact, you can find that information in the policy. The names of your panel members are available on the website as well as in the policy. So again, you'll be able to find people if you want to contact someone. So the bottom line is we all have a right to a safe and professional work environment here in the State House. We are all part of making this a positive culture, and we all have a right to report discrimination and take action to make it stop. It doesn't matter whether you're the most junior member in the House or the most senior member, or you're the lowliest part-time seasonal staff, or someone who has been here for 30 years. You have the right to make discrimination stop, and you have the right to a safe and professional working environment. Are there any questions? Yes.
Thanks, Damien. Can you go back to the slide before the panel?
Sorry, which slide?
It was the one right before the panel description.
Just tell me when to stop.
I will. Thank you.
This is the moment when I wish I hadn't put the animations in the PowerPoint.
So wait, go stop. Sorry, go. I'll just ask my question. Maybe we can find the slide.
Okay.
There was a list of sort of informal options and formal options before the panel procedures happen. And in thinking about the responsibility of hypothetically a chair, if someone brings a discrimination complaint and they are not interested in me reporting it necessarily, and what is my obligation in terms of acting on something informally or formally if the person that I am speaking with does not want me to act formally?
So if you're a chair,
It was the slide right before this one.
Yeah, I know, it's actually frozen on me.
Oh, cool.
So I apologize. I'm trying to go back and it is just not catching up with me. So if you're a chair or a member of leadership and someone comes to you with a complaint or describing behavior that you think might be a violation of the policy, one, I would welcome you to contact me or to contact Arlene Donovan from Human Resources to discuss it, especially if you're not sure of how to proceed. We're here as a resource to you. The conversation is entirely confidential. But if it's clear that the behavior could continue, so let's say, for example, as a committee chair, you have a witness who comes into committee and uses derogatory language or racial slurs. As a chair, your obligation is to ensure that that stops. So that could include conversations with that witness and telling them that that's not appropriate and that it needs to stop. It could include not scheduling them as a witness in the future, requiring them to submit written testimony. And it's going to depend situation by situation. Obviously, in that situation, we have to balance the ability of the public to speak to their representatives with the requirement to protect people here. And these issues get complicated, which is why I would encourage you to discuss it with counsel. If it's between two members of your committee, at that point, again, you need to decide, is it likely to repeat? Is it a one-time thing where I can talk to the member who engaged in the behavior and just say, hey, that was out of line today. I really want to make sure that doesn't happen again. Or do you need to do something more significant than that? So the bottom line is your response is going to depending on what the situation is. And if you ever have any doubts about whether you're responding correctly, your first step is to talk to counsel, human resources. You can also speak with leadership, or if it's an issue related to procedures in the chamber, you could speak to your House clerk. There are a lot of options, but I would advise you, whenever you're unsure of how to proceed, to speak to someone who's more comfortable with the procedures and the potential legal requirements that you might face as a chair. Other questions? Okay, seeing none, thank you for your time. I really appreciate it, and I look forward to seeing all of you around the building in the coming days and weeks. Have a good weekend.